When we work with clients that have limited liability companies, we're often asked to either draft or revise their LLC operating agreement. And we get asked, how long does this LLC operating agreement really need to be? Does it really need to have all these provisions and legalese and exhibits included? Well, one important thing to understand about LLCs that's different from many other legal forms of entity like corporations is that limited liability companies are essentially creatures of contract. And that contract is your LLC operating agreement. So we need to make sure we include a lot of provisions in there, such as how are decisions made within the company. And one decision might be whether or not to expense this business lunch, and another might be whether or not to sell the company. And you need to have a way to address those two scenarios and everything in between. We need to account for the number of owners. How many owners will this company have? Because a company with two 50-50 owners is actually a very difficult company to document in an operating agreement. Whereas a company with a dozen owners may be easier in some ways, but may have its own set of complexities. What happens when one of the owners dies or becomes bankrupt? We need to account for these types of situations in this agreement. You know, LLCs are great because they're flexible, but with that flexibility comes the potential for complexity. For example, might you want to have different classes of ownership so that certain owners have different rights and obligations from others? So we don't want the LLC operating agreement to be any longer than it needs to be, but we do want it to be long enough that it adequately addresses the things that LLC owners are likely to face in their business.